Welcome back, everybody, to Public Law. In this lesson, we're going to be talking about the fundamental principles of the UK Constitution. Now, this is going to be the subject matter for the next few lessons, and this is just going to be an introductory lesson to overview and take an introductory look at these principles in more detail. So, thus far, what we've been doing is exploring the various different principles which we can say adheres to the generic theory of the Constitution. So we're talking a little bit more about constitutional theory, the nature of constitutions, the nature of entrenchment of law, the nature of codified versus non-codified constitutional frameworks, the nature of amendments, etc., etc., etc. This lesson is going to look at some of the principles which you will argue are unique to the UK's constitution. Now, not all of them are specifically unique to the UK's constitution in the sense that you can only find these principles within the UK's constitutional framework, but some of them are, and we have our own unique spin on some of the more generic principles as well. So, like I've said, this isn't going to be an in-depth analysis of each of these principles because they are going to be the topic of a series of lessons following this. We're going to talk about them in more detail as their own separate series of lessons. But this is just going to be an overview and an introduction to some of the most fundamental concepts. So, the fundamental principles of the UK Constitution are as follows. If we were to just list them out, we'd be talking about the idea of the separation of powers. We'd be talking about the concept of the rule of law, and we'd be talking about the concept of parliamentary sovereignty. Those are arguably the three most important fundamental principles of the UK Constitution. You may also throw into that mix things like the nature of constitutional monarchy, and we will talk about the nature of constitutional monarchy when we look in more detail at the sources of the UK Constitution and looking at the role of the prerogative within the modern conception of constitutional law. But for the most part, the most important principles that we can think of when it comes to the UK's constitution are the rule of law, the separation of powers to an extent, and also the principle of parliamentary sovereignty, arguably the latter of which being the most important principle. So ultimately, the rest of this lesson is just going to be an examination of each of those principles in their overview, in their generality, beginning first with the separation of powers. Now, arguably, the concept of the separation of powers is something of an ancient doctrine, and the idea here is the rule that power within some kind of constitutional or governmental structure ought to be separated into specific adjudications or specific jurisdictions, or sometimes described as different branches, and these are considered to be branches of government. Now, the aim within the concept of the separation of powers and the fundamental rationale for the separation of powers pertains to this idea of having a government and having different areas of government which are mutually exclusive and separate from each other being able to exercise different kinds of power. Now, at least in the more modern sense, we can talk about the separation of powers from a theoretical perspective by looking at individuals such as John Locke, who wrote his second treatise of government in 1689. And we can see from this sort of Enlightenment political philosophy that the separation of powers is considered to be something of a check on the concept of totalitarianism and the concept of ultimate sovereignty of authority. Something that was increasingly and intentionally being challenged, at least during the Enlightenment period, in a number of parts of the world. Of course, within the 1700s, you see things like the French Revolution. You also see things like the American Revolution, which were considered and are representative of a revolt against this idea of sole sovereignty and all-powerful omnipotence of the monarch. And so, as a result of this, we can sort of contextualize John Locke's thinkings when it comes to the separation of powers in this general mindset, the idea that we ought not to separate authority, that we ought to not have a fusion of powers in the way that ultimately leads to a totalitarian state. It leads to a dictatorship whereby a single individual or a single organization or authority has all of the governmental power, and there is no check or accountability for that power in question. So Locke looks to distinguish along three main branches when it comes to the separation of powers in his conception. He looks to make a delineation between the legislative branch of government, the executive branch of government, and what he describes as a federative branch. Now, where this is a clear elucidation of the separation of powers, it does fail to mention the concept of judicial authority. So in today's modern conceptions of the separation of powers, we have replaced the idea of federative branches of government with this idea of the judicial, the idea of having a legislative, an executive, and a judicial branch of government authority. Secondly, then, we have the rule of law. Now, the rule of law is, to many people, and in a number of different ways, considered to be the most fundamental principle of the UK's constitution, despite being difficult to define in and of itself. In fact, when we talk about the concept of the rule of law, we can look to individuals who try to elucidate the concept of the rule of law, but do so in a different way. They do so by talking about the fundamental characteristics of the rule of law, rather than trying to delimit a precise definition. According to T.R.S. Allen, for example, in the mouth of a British constitutional lawyer, the term rule of law seems to mean primarily a corpus of basic principles and values which together lend some stability and coherence to the legal order. So rather, in this, as this quote suggests, than just looking at trying to make a definition of the rule of law, a constitutional lawyer may look to the rule of law and find and see a number of basic principles and values, rather than a specific definition. And so along this line, looking at the rule of law is less necessarily about trying to find this concrete and all-encompassing definition that you could just look to a dictionary, but rather looking at a number of basic principles which together form the basis for what we could describe as the stability and coherence of a legal order, and therefore be able to find the stability of this principle of the rule of law. Finally, then, as we look at principles of the Constitution, the last one that we're going to examine is this idea of parliamentary sovereignty. Now, it's a principle which is borne out, at least in the most fundamental way, from the Glorious Revolution of 1688. However, when we look at the history of parliamentary sovereignty, we will note that the tensions that existed in the 1600s between the monarchy and parliament sort of was this slow embryonic development of the idea of parliamentary sovereignty, going all the way up to 1688 and the Glorious Revolution. But what parliamentary sovereignty essentially tells us is that Parliament has the ultimate authority to make and unmake any law they so choose. And so what this means is the Westminster Parliament is the supreme legislative authority within the United Kingdom. And it also means that the judiciary and the courts, more generally, are beholden to parliamentary statute. And so too are the devolved institutions, so things like the Scottish Parliament, the Welsh Assembly, and the Northern Ireland Assembly. And ultimately, we can think about the fact that there may have been some challenges to the principle of parliamentary sovereignty. We'll get into this in more detail when we look at these specifically. But things like, for example, the Human Rights Act from 1998, our former membership of the European Union, as well as this theoretical dividing line that is placed by A.V. Dicey between the idea of legal and political sovereignty, all seem to represent something of a limitation on what parliamentary sovereignty actually is, and the extent to which Parliament is the supreme legislative authority within the United Kingdom. In the previous lesson, what we did was examine the fundamental principles of the UK's constitution. And we did so from a sort of generic introductory perspective. We talked about the concept of the rule of law, we talked about the concept of parliamentary sovereignty, and we also talked about what is going to be the first of our concepts that we're going to explore in more detail, this idea of the separation of powers. Now, ultimately, what we're going to do in this video is start to look at these principles in more detail. So we're going to take the first of the fundamental principles of the UK Constitution, this obviously being the idea of the separation of powers. I'm going to talk about how this is operationalized within the UK's constitutional framework. So fundamentally, the separation of powers is quite an old concept. To an extent, you may argue that it has its ancient and Aristotelian origins in some regards. But in terms of its modern conception and the way in which we can understand the separation of powers today, we can really date ourselves back to the more Enlightenment philosophers that exists. For example, provincial French nobleman Montesquieu argues that ultimately, when legislative power is united with executive power in a single person or in a single body of the magistracy, there is no liberty, because one can fear that the same monarch or senate that makes tyrannical laws will execute them tyrannically. Nor is there any liberty if the power of judging is not separate from the legislative power and the executive power. If it were joined to legislative power, the power over the life and liberty of the citizen would be arbitrary, for the judge would be the legislature. If it were appointed to executive power, the judge could have the force of an oppressor. This is really a passage that explains what the importance of the separation of powers ultimately entails, why the separation of powers is an important concept. Because if power was not separated, if you have these distinct concepts when it comes to government structure, the idea of making laws, executing laws, and upholding laws, and that they were all united under one single unitary body or one single person, then you have this idea of tyranny. You have somebody who is able to make a tyrannical law and then also execute the tyrannical law and have no pushback in doing so. When we have a separation of powers and when we have checks and balances on each of the branches of government, you have the ability for certain branches to potentially pass tyrannical laws, but then for other branches to check that authority and to ensure that those tyrannical laws are not executed or not upheld, for example. And so really the common understanding here is the rationale behind the separation of powers. And we can see the traditional rationale in this formal passage. The aim here is, of course, to preserve the liberty of the citizenry by distributing state power across various and separate distinct branches of government. Remember that what is happening when we talk about the relationship between the people and government is the people are delegating to the state a significant amount of authority. We are, as people, delegating to the government the ability to make laws that we have to follow, to uphold those said laws, and to hold the people to account if those laws are broken. So the general idea here is, well, we are trusting in the government a certain amount of power. And so in order to preserve the liberty of the citizenry, that power has to be checked. And one way in which it is checked is through the separation of powers, by distributing authority across different branches. Another way, of course, is through democratic election, as you can probably understand. So the result of which is that no one branch becomes too powerful, and so the insurance here is that we do not have the suppression of civil liberties. So given that that's the rationale for the separation of powers, what do we look when we see the separation of powers as applied to the United Kingdom? Well, ultimately, the traditional understanding of the separation of powers entails a delineation of authority between three major branches of government. We have an executive branch of government, we have a legislative branch of government, and we have a judicial branch of government. And this is what is considered to be the traditional understanding of separation of powers, at least from a level which is from the same level, should I say, because in some cases you have a federal state where not only is power separated horizontally across three different branches, but it is also separated vertically between federal, state, and local government institutions. In the US, we have these three branches of government, for example. At the federal level, so making it clear that we're talking about this at the federal level, the US Constitution outlines three distinct branches of government. We have the executive branch, which is representative at the federal level with the president and the White House mostly. We then have the legislative branch, or the legislature. Again, this is represented by Congress, the houses of Congress, the House of Representatives and the Senate. And then you have at the federal level the Supreme Court, which represents the judiciary. And the Constitution outlines that each of these three branches will have the power to check all of the others. And it also makes it very clear that these three branches are clearly distinct and separate branches. You cannot be, for example, a member of the executive and a member of the legislature at the same time. Sometimes you have members of Congress who want to run for president. They would have to resign as Congress or as Congress people, or at least don't run for re-election during a congressional election, in order to then run for presidential election instead. And if they fail, they can go back to Congress, but they cannot hold the position of being a member of Congress and a member of the executive at the same time. This strict and constitutionally mandated separation of powers, however, does not exist when we apply our principles to the United Kingdom. Because one of the reasons why is because we have an uncodified constitution. We don't have a specific document which outlines the exact ways in which the different branches of government have relationships with each other. Instead, we have what is sometimes described as a partial separation of powers. So rather than having, for example, an executive and a legislative branch which are both completely distinct and separate, these institutions are in fact fused. So we have the fact that the government, the executive branch, sits in Parliament and has parliamentary legislative authority. It has the authority and contributions to the passing of law. Now, this is not to suggest that they are so merged that we cannot delimit them. We cannot delineate between the government and the legislature, or between government and parliament within our system. But it's just that they perform similar functions. They perform the same functions. They sit in the same institution. And so, in the next lesson, we'll go through essentially the ways in which the separation of powers is applied to the UK system. We will talk specifically about this idea of a fusion of powers between the executive and the legislative branch. We'll talk about the changes in separation of powers when we looked at the ways in which the judiciary has become separated from this legislative centre. And we'll also talk about the role of specific institutions, such as that of the role of the Lord Chancellor. In this lesson, what I want to do is talk about the separation of powers as applied to the United Kingdom, or should I be more precise, the lack thereof of separation of powers in the United Kingdom, and the ways in which reform over a few years has led to changes in this particular process. So, the previous lesson, we explored the concept of the separation of powers from the general perspective of constitutional theory. We looked at the example of the United States being quite a significantly separated constitutional structure when we talk about the separation of powers. In this lesson, we're going to spend some time looking more at the concept of the separation of powers, but specifically applied to the system of the United Kingdom. Asking the two major questions: do we have a separation of powers in the UK? And the second question is, how have reforms established a greater separation of powers in the United Kingdom? Now, the second question almost answers the first, given that you wouldn't be correct to say that we have a relatively limited separation of powers in the United Kingdom. As a general recap, though, the separation of powers is a principle which refers to the separation of the various functions of government. You have often divided into three different distinct institutions. You have those who make the law, the legislative branch of government. You have those who enforce the law, the executive branch of government. And you have those who administer and interpret the law, the judicial branch of government. In the UK, this distinct and complete separation does not exist in the exact same way. Compare that to the United States, where the three major branches of government, at least at the federal level, are completely distinct and separate. You have Congress, which is the legislative branch, you have the presidency and the White House, which is the executive branch, and you have the Supreme Court, which is the judiciary. All of which are separated, all of which have checks and balance over each other to ensure that no one institution gains too much authority and power over the other two. In the United Kingdom, though, we do not have this exact same structure. Instead, there are numerous instances where the branches of government in the United Kingdom don't have separate and distinct roles. In fact, they actually share powers. We have what is known more colloquially as a fusion of powers in the United Kingdom. Before 2009, for example, the legislative branch had both legislative and judicial powers, with the highest courts in the land being the Appellate Committee of the House of Lords, sometimes described as the Law Lords. So when we think back to previous cases and quite old cases being appealed, you may see in your citation the letters HL, which refers to House of Lords. This is because this was a judgment that went up and was handed down by the House of Lords, by the Law Lords, the Appellate Committee of the House of Lords. The executive branch had executive functions, but also legislative functions, in the sense that they sit in the House of Commons and pass legislation. This isn't even had. This is has. This is what has. This is currently the case in the structure of the United Kingdom today. The executive branch has both legislative and executive functions in the ability to pass policy, to interpret policy, but also to pass legislation. The government also performs judicial functions in the sense that they make determinations on appeals for town and country planning legislation. Again, these are legislative functions but are performed by the executive branch. Again, another example of the fact that the various branches of government do not necessarily share powers, but do not necessarily have separate powers, but actually share and have a fusion of powers. One may also be able to argue that the judiciary has the ability to make law, in the sense that they can contribute to the common law. However, you could also argue that this is, while this is lawmaking, this isn't the business of making legislation. So those who make the law is different to those who create and contribute to the common law through precedent. So this is a relatively weak argument that you can make, but you can still present that as a system that exists. One of the most important principles of the separation of powers, or at least one of the most flagrant disregards of the separation of powers, is the role of the Lord Chancellor. The Lord Chancellor is seen as the most egregious example, or at least was seen as the most egregious example, of a lack of the separation of powers, because the Lord Chancellor traditionally had the roles of quite high up and quite prestigious roles within all three branches of government. Traditionally, the Lord Chancellor would have the ability to sit and contribute to decisions made in cabinet meetings. They were members of the cabinet, which gives them executive authority. They were also the head of the judiciary, giving them judicial authority, and they also sat as the Speaker in the House of Lords, giving them legislative authority. Three major powers within three major branches of government. And so the role of the Lord Chancellor was seen as the most significant and egregious example of a disregard of the separation of powers, and was just the most pertinent example of a fusion of authority between three branches. And as a result of that, we've seen reforms to the role of the Lord Chancellor with the constitutional reforms that came in within 2005. The Constitutional Reform Act, which was introduced by the new Labour government, made a number of reforms to the Constitution, as you may have guessed, and as a result of which, we see some reforms made to the role of the Lord Chancellor. We'll examine the second thing that they did in a second, which is the establishment of a new Supreme Court, but we'll focus first on the reform to the role of the Lord Chancellor. Following the passage and entering into force of the 2005 Constitutional Reform Act, the Lord Chancellor had their judicial functions removed, and they no longer sit in the House of Lords as the Speaker. This represents a significant representation of a separation of powers. What is interesting is there were definitely debates and the possibility for the role of the Lord Chancellor to just be abolished, to abolish that institution completely, but owing to pushback, they simply made reforms to this position. Finally then, the highest appeals court in the UK, which of course was the traditionally presented as the Appellate Committee of the House of Lords, or the Lords of Appeal in Ordinary, was changed as well as a result of the Constitutional Reform Act. It essentially removed the role of the Appellate Committee of the House of Lords and established a new and independent Supreme Court of the United Kingdom of Great Britain and Northern Ireland. In terms of the jurisdiction and the legal cases, very little changed. In fact, there is very little in terms of the distinction between the Law Lords and the Supreme Court. In fact, the original Supreme Court members, the Supreme Court justices, were just members of the House of Lords previously. So that's in terms of the structure, that is a minor change, but the Supreme Court represents a little bit of clear blue water between the legislative branch that sits in Parliament and the judicial branch, which now sits across the square in the old Middlesex Hall in the Supreme Court. And so the result of which is showing, at least on principle, that there is a separation between those who make the laws and those who interpret and have to enforce the laws.